Hello, all. Welcome to another session of this extremely interesting course titled Legal Essentials for Human Resource Management. Now, if you remember our discussions, this is our fifth week, and every week we were earmarking ourselves for a particular topic. And fifth week was dedicated for discussions on social security as well as well-being. In the last class, we discussed about Maternity Benefit Act, one of the very popular as well as a very effective well-being act, which promotes and supports well-being of women when they are going through their phase of labor. Now that we are completed with Maternity Benefit Act, let's move ahead to another women focused and a very relevant act, which is titled Prevention of Sexual Harassment at Workplace Act 2023, popularly called as the POSH Act. And in today's session, we look at some of the basic definitions of this act. Now, when I started our discussions, I started with an argument that the whole purpose of this course is to bring in dignified workplace. I told you that it's my philosophy that we should have workplaces, we should convert workplaces into dignified places of work, and this course is one such attempt towards creating dignified workplaces. And make no mistake, if any one specific act has to be cornerstone, has to be important, I would say it's this act. See, the point is very simple. If you make women at a workplace comfortable and safe, trust me, 50% of this objective of creating a dignified workplace is achieved. So in that sense, this course is extremely relevant. I would suggest and request all my course participants to understand nuances, definitions, intricacies of this act in a detailed manner and apply the wisdom that you will get from this session into your respective workplaces so that we can create safe workplaces, dignified workplaces. Now, with that statement, let's move ahead to our discussion on Prevention of Sexual Harassment at Workplace Act of 2013. And if you have noticed the act, it's in the bracket, you will see three words, which is prevention, prohibition, and redressal, which essentially is what this act ensures. It intends to prevent all sorts of sexual harassment at workplace. It intends to prohibit any such activities at workplaces, and let's say in case some harassment happened, how it can be properly readdressed, how redressal can happen. So the entire act discusses all those mechanisms. So without much delay, let's get into the discussion on this act, POSH Act 2013. And I hope you know my name by now. My name is Dr. Amish Samalopanan, and I am from Nalsa University of Law, Hyderabad. Now, sexual harassment as a form of gender discrimination is clearly a violation of women's fundamental right for equality, right to work with human dignity, and right to life. And if you remember our discussions on session 2, where we were looking at various constitutional basis for many of this workplace act, we had discussed that Article 14 and Article 15 directly links with equality, and how Article 19(1) and Article 21. Article 21 discusses about right to life. Article 19(1), especially G subsection, speaks about work and having a dignified work. Article 14 and 15 clearly speaks about equality. So a sexual harassment at workplace is clearly a violation of fundamental rights of women. So it's that serious of an aspect. Of course, Indian Penal Code, now it's Bharatiya Nyaya Samhita. There are sections which addresses sexual harassment, especially at the workplace context, and there is penalty for offenses of sexual harassment as well as outraging the modesty of the woman, and as well as assault or criminal force to the woman with the intent to outrage her modesty. So a lot of aspects of sexual harassment is covered, but in 2013 there came in a very specific act which purely addressed sexual harassment at the workplace. Now, the objective of this act is to prevent and protect women against sexual harassment at the workplace, and to redress complaints of any sort of sexual harassments that has happened at the workplace, that too in a very timely manner. Now, let's look at the genesis of this act, and it all started with an incident that happened in 1992. So there was a Dalit woman called as Bhanwari Devi, and she was a social worker, and she was employed in this rural development program of government of Rajasthan. So she used to get involved in a lot of social atrocities, and during one of her engagements, while one of those acts, she got gang raped. Now, Bhanwari Devi went to police station and many other places seeking justice, but it was not properly addressed. That's when an NGO called as Vishaga came into the picture, and they filed a public interest litigation in the Supreme Court and demanded justice for Bhanwari Devi. So the major prayer in this PIL, public interest litigation, was that the court should act against the sexual harassment at the workplace, and Supreme Court recognized that there is a legislative inadequacy in the country when it comes to addressing sexual harassment at workplaces, and the court set out gave a set of guidelines which was known as Vishaga guidelines, and these guidelines became the structure on which the POSH Act was built. So if you remember all our discussions till now, you'll say that often a judicial interpretation, a judicial suggestion, and judicial guidelines often leads to a newer act in a later stage. So this is a story. So some of the important features of the Vishaga guideline is that it set out a detailed framework for prevention of sexual harassment of women at workplaces, and these guidelines recognized the need to give a justifiable punishment to those people who have indulged in the act of sexual harassment. That was the first thing. And the Vishaga guidelines would have the effect of law under Article 142 of the Constitution, and it have to be mandatorily followed by the organizations in the private and the government sector. So the first time we had a blanket law which would address this issue of sexual harassment at workplace that too without a sectoral differentiation. It was applied everywhere. So that's how this entire act came into being. Now, the applicability of this act, applicability of POSHA Act, is that it is applied all over the country. It is organized sector, unorganized sector, doesn't matter. Blanket applicability of this act is there. Some of the questions that people often ask is that, is this act applicable for trans women? So this question was asked in Anamika versus Union of India case, and the Delhi High Court held that trans women were accorded the same rights as a woman under the POSH Act. So if you are a trans woman, if an atrocity happens against a trans woman, the provisions and the protection of this act is extended to them also. But what if a man has been sexually harassed at a workplace? This act doesn't cover. So it is exclusive for women as well as trans women. Another question that arose was that, okay, we understand that a woman has been sexually harassed by a man and then we file a complaint. What if a woman have sexually harassed me? Can I still file a complaint? So this question emerged in Malabiga Bhattacharjee versus Internal Complaints Committee of Vivekananda College. And the High Court of Calcutta said that, yes, you can file a complaint against women also if they are the perpetrator. Now let's look at certain important definitions in this act. So the first definition that you look at is aggrieved woman. Now, why is this definition important? The complaint can only be made by an aggrieved woman. So, who is an aggrieved woman? So, aggrieved woman in this ambit of workplace could be any woman in the workplace who has alleged to have been subjected to the act of sexual harassment irrespective of their age. So any woman, that also includes trans women, who alleges to have been subjected to the act of sexual harassment, that becomes an aggrieved woman. She is an aggrieved woman. And there is nothing to do with age. Women of any age can raise the complaint. And if you remember all our discussions till now, most of the act is not applied on apprentice, interns, I told you, and we have discussed the logic behind that also. But in the definition of aggrieved woman, the trainees and apprentices and interns are also included. So all the trainees, all the apprentices, probationers, even if you are a customer or a client who came to the workplace and then you've been harassed, you are still the aggrieved woman. So it's more the place that becomes the key in this definition, and you being a woman. If you've been subjected to sexual harassment in that particular workplace, you fall under the definition of aggrieved woman. Now, I told you aggrieved woman has to be an employee also. So let's see who is an employee, so that the complaints are made against the employee of the workplace. So any regular temporary individuals who are engaged on daily basis as ad hoc employees, co-workers, trainees, probationers, doesn't matter what form of job you are involved in, you are counted under the definition of employee. You are a contract employee, non-contract employee, employed through agent, doesn't matter, you're covered under the definition of employment. You are with or without the information of a principal employer's knowledge, you are still included in the definition of employee. You're working for remuneration or not, or voluntary service or not, still counted under the definition of employee. So it's a very broad definition of employee. Everyone and anyone who is working at that particular workplace is covered under the definition of employee. Now, what is sexual harassment? We have defined aggrieved woman. We have defined the employee. Now, what is sexual harassment? And this act provides a very broad definition of sexual harassment. Some of you might feel that is it actually sexual harassment given the broadness and the depth of the definition of sexual harassment, but you should understand that it's an act which intends to make workplace safe. So any act that makes a woman unsafe in her workplace will come under the broader definition of sexual harassment. So let's see how is sexual harassment defined in this act. Any unwelcoming act or behavior, including physical contact and advances, demand or request for sexual favors. You can't say that I didn't do anything. If you have demanded sexual favors also, it comes under harassment. Making sexually colored remarks, showing pornography, or any other unwelcomed physical, verbal and non-verbal conduct of sexual nature is included in the definition of sexual harassment. So as I said, it's a very broad definition. So I'll give you certain circumstances which, so that this definition, you might feel that it's a very, very broad definition. How actually can you so I'll give you certain circumstances, and among these circumstances occurs, there are other circumstances also, but these are indicative circumstances. If they are present in relation to or in connection with any act or behavior of sexual harassment, may amount to sexual harassment. So some of them are: first, implied or explicit promise of preferential treatment in employment. So that is established that I'll give you a preferential treatment if you indulge in a particular activity or not. Those kind of promises are also harassment. Implied or explicit threat of detrimental nature in employment. If you don't do what I ask you to do, more on terms of sexual harassment. So please do read the initial first statement. So, and the circumstances are these. So this will give you a clarity. Any implied or explicit threat about present or future employment status, and then you indulge in any unwelcoming behavior or act, again harassment. Interference with work or creating an intimidating or offensive or hostile work environment, again sexual harassment. Or any sort of treatment that is likely to affect an lady employee's health or safety, again it is counted under sexual harassment. So it's a very broad definition. There are many aspects to harassment. It's not just a physical advancement. It can also be other forms of harassment in terms of threats, promise of a better thing in exchange of a favor, showing pornography, or even a sexually colored remark which you may be used to at your previous workplace, but in the new workplace the woman have taken an offense, and yes, the statement you made was a sexually colored statement. It still comes under the definition of sexual harassment. So as I said, it's a very broad definition. Now, why is this so broad? The definition of sexual harassment under this act is very broad, so that it can cover all sorts of direct and implied sexual conduct which includes physical, verbal, and written contact. So you should always understand that most of this acts of harassment happens in a private place, and then you cannot approach these harassment complaints in a in a traditional manner where you have to seek direct proof. So, and you cannot also cling on to this defense that nothing physical has happened. No, because at the end of the day, do a woman feel safe at the workplace is what this act intends to check and to intends to promise. By that nature, uh, it's a very broad definition of sexual harassment. So, continuing from last slide discussions, any advance of sexual request with a promise in increment in salary or promotion at the workplace, you might casually have remarked it. I've seen a case where that the defense by the respondent was that it was a casual remark. I didn't mean it. It was supposed to be a joke, but no, it's not a joke. So if you say that you'll get a promotion, why don't you just come for a date with me, or maybe indulge in a little more activity? Clear case of sexual harassment. Similarly, any threat of demotion, issuance of frivolous memos purely with the nature to harass the woman, extra workload on the account of sexual requests not being fulfilled. These are realities. And if you meet that, please use this session as also a session of self-reflection. If you have ever made any such statements thinking it's a joke or a casual comment, please do understand that it's legally it is defined as sexual harassment. Teasing, voyeurism, taunts and explicit sexual connotation, taunts with sexual connotations. Movies glorify these. You think it's pretty cool that you sit in a public place and call out a name to a woman with a sexual connotation, and the other people laugh around it. You think it's pretty cool, but trust me, the law calls it sexual harassment. Giving gifts or leaving objects that are sexually suggestive. You casually slipped a sexual object, sexually or suggestive object. Sexual harassment. Showing pornography, making or posting vulgar, indecent sexual pranks. You just took a photograph, or even without a photograph, wrote a indecent comment in the WhatsApp group or in your Facebook page about a particular woman employee just because you didn't like her, or you like her but you thought it's pretty cool to call out such things in the social media. It is again sexual harassment. Eve teasing, making jokes on women, or demeaning or offensive pictures, showing them offensive pictures, and that pictures can even be cartoons. But if it is sexually suggestive, it is sexual harassment. I've always heard men saying this is a little too much of a definition. How is it a sexual harassment if I show her a small adult joke or a adult cartoon piece? It's at the end of the day, it's a cartoon. See, you have to think from the viewpoint of the woman. With a friend, and if he or she doesn't take it as offensive, it's fine. But you cannot believe that every single woman might take it as a joke. So you have to be very careful in sharing such content. And given that these you say that verbally, the burden of proof is a little more heavier. given that somebody would have said it, then it becomes he said versus she said. But when you send this meme, sexually suggestive memes, there is a clear digital trail which can be traced back. So it's not a joke, and there's a clear chance that you can be you can be in trouble because of this. And you could also not say that, madam, I didn't send any email or SMS. It was Snapchat, or it was Instagram. No, any social media or any sort of communication channel, it is still counted as sexual harassment. Couple of more things I would like to cover along with this, so that the definitions are very clear. In Global Health Private Limited versus Local Complaints Committee, LC Committee of District of Indore, there was this case where the petitioner was accused of sexually harassing the complainant by commenting on the complainant's dress and outfit that she wore to the workplace. Now, if you have understood the definitions of sexual harassment clearly that we were discussing for last 10 minutes, you know that this is sexual harassment for sure. Any sexually colored remarks that is made on a woman is sexual harassment. But the petitioner went to the court, saying that probably this is not a sexual harassment. So the petitioner approached High Court of Madhya Pradesh for quashing the LC inquiry report in which he was held guilty. Court said that it was indeed an unwelcoming sexual behavior at the workplace, and the act of the petitioner created an intimidating and hostile work environment for the complainant. So that's what I was saying from the beginning. The problem or the whole logic behind such a broad definition of sexual harassment is that anything and everything that can make the workplace hostile towards women, that has to be checked. That's why the definition is so broad. In another case, Nisha Priya Bhatia versus Union of India, the Supreme Court held that the approach in regard of the cases of sexual harassment at workplace is not confined to the cases of actual commission of acts of sexual harassment. Please to understand, it's very important. It's probably the heart of the entire inquiries of sexual harassment at workplace. So please do understand the cases of sexual harassment at workplace is not confined to cases of actual commission of act of sexual harassment, but also covers situations wherein women employees subjected to prejudice, hostility, discriminatory attitude, and humiliation in day-to-day functioning at the workplace. So any such act that creates hostility, prejudice, discriminatory attitude, and humiliation at workplace comes under the broader umbrella of harassment. Now, with final definition we look at is the definition of workplace. Now, the definition of workplace according to this act, please do understand, this act says workplace, but it doesn't mean that just that perimeter within the walls of the workplace. No. By that logic, if the lady employee is at her work, is at her home, you can text anything because she's no longer at workplace. So please do understand the scope of the workplace is not just limited to the place in which employment happens, but it's actually an extended workplace. It could be any place of visit by an employee arising out of employment or during the course of employment, including transportation provided by the employer for the purpose of commuting to and from the place of employment. So, at the workplace, outside the workplace, if it was work related thing, even transportation provided, if the harassment happens, it still comes under the ambit of workplace harassment. So the Gaurav Jain versus Hindustan Latex Family Planning Promotion Trust and others case in Delhi High Court, the court upheld the decision of the employer to terminate the employment of the accused in line with the recommendations of the IC committee, internal committee, where the accused was alleged to have sexually harassed a female colleague during an outstation visit for work. So it was supposed to be an outstation visit, nowhere closer to the original workplace. Still, it comes under the ambit of sexual harassment. Another popular case is the case of Silajit Guha versus Sikkim University. The Sikkim High Court observed that the definition of workplace under the POSH Act is inclusive and not an exhaustive one. So anything that is emerged during the course of employment can be called as workplace. In the Jaya Kodate versus Rashtrasant Tugdoji Maharaj Nagpur University case, the Bombay High Court had observed that the definition of workplace under POSH Act is inclusive and has been deliberately kept wide by the Parliament to ensure that any area where women may be subjected to sexual harassment is not left unattended or unprovoked for. So that's the spirit of this act. Anywhere harassment happens, it is related to workplace. You know that lady from the workplace, and it's essentially an extension of workplace relationship that has led to the harassment. It's a good chance that it has been covered under the definition of workplace. So with that note, let's conclude today's session. I'm sure by now you're well aware about how this act came into being, what was the need for POSH Act, what is the scope of this act, what are the various definitions of aggrieved woman, of employee, of workplace according to this act. Now that you have a clear idea of all these concepts, let's move ahead in our next session on discussions on how to actually address a sexual harassment complaint at workplace, and what are the various duties of an employer according to this particular act. What are the duties of the employer to ensure that any sort of such sexual harassment will not happen at workplace. So we'll discuss all that in detail in our next session. Until then, let me take a small break. You have a great day ahead. Let's meet in our next session to have further discussions on this act. Thank you so much.